Hi, welcome to NCLC's session on how and why legal services attorneys and others should do regulatory advocacy. I'm Diane Thompson with the CREA project, and I'm so thrilled to be here. NCLC is really one of my deep and dear homes. As many of you know, I started out as a legal services attorney and then spent 7 years working at the National Consumer Law Center on mortgage issues during the foreclosure crisis. And then I spent 5 years at the Consumer Financial Protection Bureau working in their Office of Regulations. And what I want to do with this next phase of my life is take what I learned while I was at the Consumer Financial Protection Bureau about how regulations are written, how you can persuade agencies, how we can unleash this power that we have in regulatory advocacy on behalf of racial and economic justice for all marginalized communities. We're going to go into the polling questions now, and you'll see the first polling question come up. Please take a minute. We're just trying to get a ground set for where people are in their experience with regulatory advocacy and what they've done in the past. Today's agenda, we're going to start by talking about what regulatory advocacy is and why we want to do it, what the key strategies are for effective regulatory advocacy, how do you get started, where do you begin, what you should know about administrative law, and how do you write an effective comment to a proposed rule. Who decides what we pay for our credit cards, student loans, bank accounts, and mortgages? Corporations decide. They have to follow rules in making those decisions, rules written by agencies in DC. Too often the agencies writing the rules only hear from corporations. If we tell the agencies what we think, we can change the rules. We've got materials to help at our website, creaproject.org. That's CRREA project.org. Please check them out and tell us what you think. There are a couple key takeaways that I want us to think about why to do regulatory advocacy. In the consumer financial space, everything we care about is set by regulation. It is not enough for us to win the legislative victories or even victories in the courts. We have to win the regulatory victories. It's those regulatory victories that govern whether or not the statutes that we've worked so hard to get passed, whether or not Dodd-Frank will survive, whether or not the CFPB itself will survive. All of that depends in large measure on what happens in the regulatory arena. The other point I think that's real, so there's a lot at stake here for us, but I also think that it's much easier for us to win when we do regulatory advocacy than it is for us either in the legislative space or fighting individual cases or even class action cases. When you win a regulatory fight, that has the power of the broadest class action you could ever bring. It applies to the entire universe. It can apply to the entire market and to everybody going forward. It doesn't just look backwards at what the law is, it changes what the law is for everybody going forward. And unlike legislators, and we'll talk about this more as we talk about how to write an effective comment, agencies are required to listen to everybody. It's not pay to play. Everybody's comment counts, everybody's voice counts. And agencies, because they're required to listen to everybody, they have a special interest in listening to the voices from people they hear from the least. So agencies hear all the time from industry representatives. Bankers, trade associations are in at the CFPB almost every day. When I was working on the TRID rules as a managing counsel in the Office of Regulations, I would hear from somebody on the industry side, a bank, a trade association, a broker. Almost every day they would call me and they would say, here are the things we need in the rule, here's what's not working for us in the rule. We have to combat that narrative. If we want the voices of our clients and the communities we care about to get represented in the regulations, we have to be as present in the regulatory space as financial institutions and their trade associations are. And then the final pitch is, no matter who the administration is, no matter what their political agenda is, regulatory advocacy can make a difference. It can make a difference if you have a favorable administration by making sure that the rules that get implemented are ones that actually do work for our clients and our client communities. If you have an unfavorable or hostile administration, you can do a lot to mitigate those rules, and you can do a lot to slow those rules down. And we'll be talking about all of that as we go through today. What are the key strategies for effective regulatory advocacy? The first thing is, there are 3 key strategies that we think matter across the field that you always want to do whenever you're doing regulatory advocacy. These are not so different from what you do in other kinds of advocacy, but they're the 3 main things we think people should focus on the most. The first is share facts. You want to provide evidence, data, observations, experience about how the rule or the proposal impacts your community. What is actually happening on the ground, and what will be the impacts of what the agency is discussing doing. We'll talk a little bit more about this later, but it bears repeating. What agencies care about, what they need the most, what's the most persuasive to them are facts. So this is a little bit different from either working in legislative advocacy or doing litigation, where rhetorical power is more important. For agencies, rhetorical power, the emotional story, is not as important as what the facts are and your ability to marshal the facts. You want to tie into the statutory mandate always. What is the agency required to do? Agencies, when they make rules, they're exercising delegated authority from Congress, or in the case of a state agency, delegated authority from the state legislative body. That means they can't go beyond what Congress has said that they can do. So it's very important when you're doing regulatory advocacy to be aware of what the statute says and to tie your advocacy into what the statute says they can do or what it says they can't do. You can't advocate for something that's beyond the reach of the statute. You should ask questions. If you can ask questions, you establish yourself as somebody who's approaching the agency with respect, somebody who's interested in learning, and you stand a good chance of gaining information from them that will help you figure out how to pitch your advocacy. I've had people tell me, well, we tried asking questions and they all just sit there stony-faced. Then maybe you want to try in a smaller group. Maybe you want to try one-on-one. Maybe you want to ask some different questions. But you can always ask, where are they in the rulemaking? What are their concerns? What do they need from you in order to reach the goals that you're trying to do? You can ask them where they agree and where they disagree with you. So you should always ask the agency, what do they need to move forward in a way that serves their community? Up on our website and in your materials, so up at creaproject.org and in your materials, we have this quick guide to regulatory advocacy. The top of it repeats these 3 strategies that are the key strategies for any advocacy that you engage in with agencies: sharing facts, tying into the statutory mandate, and asking questions. The next thing that you want to think about, and that this guide is helping you to do, is where are you in the rulemaking process? We often think about regulatory advocacy as being confined to the comment period. It's very reactive. We think about what has the agency proposed and what do we like or not like about that. I'd like to ask us to think about shifting our focus in regulatory advocacy to before the proposal and after the final rule, because there's a lot of work that can be done at both of those points that's unused power that we're leaving lying on the field. If we can learn how to engage at the pre-rule stage, we can help set the agenda. That lets us go on the offensive, that keeps us from being purely reactive, that can get the proposals on the table that we want. And then I would also like us to think about how can we be engaged in regulatory advocacy at the final rule stage, whether we want to make sure that the agency is implementing the rule in a way that's effective, that they're not issuing guidance that undercuts the rule, and that if there's really a problem with the rule, that we're thinking about how to get the agency to revisit the rule or how to overturn the rule in the courts. The other thing that you need to think about as you're thinking about when to engage and where you are in this timeline is what your goals are. And I think, again, it's worth thinking, just taking a minute before you start writing that comment letter, you call up the agency, what are your goals? Are you trying to influence the agenda? Are you trying to speed up a rulemaking? Are you just trying to build the record? Do you want to strengthen, delay, or oppose the rule? Do you want to monitor, support, or implement a final rule, or support implementation of a final rule? Or do you just want to overturn the rule? So think about what your goals are, where you are in the timeline, what are your goals, and then what are the right tools to use? So again, we often think about commenting. That's very reactive. It's very important. It's how we build the case for the rules we want, to overturn the rules we don't like, to make sure that they're implemented in a way that's effective. But we have a lot of other tools at our disposal that all have their own unique strengths. You can ask for a meeting. You can ask for a meeting with the head of the agency. You can ask for a meeting with the team that's working on writing the rule. You can ask for a meeting with the people who are engaged in research. You can ask for a meeting with people who are responsible for outreach and consumer and community outreach. Think about whether or not a meeting is a helpful way to exchange information. You can call people. You can simply call somebody up on the telephone or send emails. You can write letters. You can think about, do you want to combine the work that you're doing with a media campaign, or do you want to try to engage congressional pressure? Do you want a public hearing? And then I think there's, you can always think, for us lawyers, one of the tools in our arsenal is always thinking about litigation. There's a very narrow window of times when you'll want to think about using the Congressional Review Act or other congressional action to overturn a rule. Those are pretty blunt tools, and they're ones that are hard to take advantage of. They take a fair amount of advocacy effort, but sometimes that's the right place and sometimes that's the most effective place. Certainly it was used a lot over the last 4 years by the Republican Congress. There's no reason that it can't also be used to strike down rules that agencies have issued under a conservative administration. So again, just to repeat, when you sit down to think about regulatory advocacy, we're asking you to broaden your perspective, to think about what you're doing as part of an ongoing dialogue with the agency, think strategically about what it is you want to do, where you can bring your perspective to bear to most influence the agenda in a way that the voices of your clients and your client communities are most effectively represented in the rulemaking, most effectively heard by the agency. We'll take a little break now for questions. Always remember that you can put your questions into the chat at any time. We'll be trying to answer these as we go along. We also have 2 more sessions for Q&A. We'll do a Q&A on regulatory advocacy on November 13th from 3 to 4 p.m. That will be live. Rebecca Smullen from Public Citizen and Seth Frotman from the Student Borrower Protection Center will be joining me. So you're welcome to, please come to that as well. Ask us any questions. That will be live. And then we'll be doing a strategy session on regulatory advocacy for economic justice on November 17th. From 3 to 4:30 p.m. and you can join us there. We'll now have a few minutes where we can take your questions live.
How do you get started with regulatory advocacy? In our previous video segments, Diane set the stage for why do regulatory advocacy, and she laid out our philosophy at CREA Project for how to do regulatory advocacy strategically. My job now is to make this all a bit more tactical. You should leave this segment with concrete next steps on how to start. I'm Kate Munoz. I worked at the Consumer Financial Protection Bureau for 7 years in a number of different roles, including Chief of Staff of the Office of Regulations. I'm an attorney and organizational development consultant, and I'm at CREA Project because I'm passionate about good government, which requires engagement from regulatory advocates like you. As a regulatory advocate, the key to effectiveness is for you to be aware of what you know about the lived experiences of your clients and of underserved communities that agency rule writers may not know. How can you start putting your knowledge to use in the rulemaking process? Let's go through things sequentially. First, how do you identify rulemaking you care about? You need to find out if any rulemaking is happening in an area of particular concern to you. If you're a legal services attorney, maybe you're particularly interested in access to wealth-enhancing credit for people on public benefits. Maybe during this pandemic, you're concerned about the rights of your clients in a foreclosure process. How do you monitor what's going on in these kinds of spaces? We at CREA Project recommend that you get familiar with the Unified Agenda. The Unified Agenda provides a treasure trove of information that can help you decide whether to engage and commit resources to advocacy on a particular rulemaking. These are the top 3 things that you need to know about the Unified Agenda. It's published twice a year. It's a 12-month look ahead of all planned rulemaking activities, and it's a database. You can search by keyword and filter on a number of criteria. You can search for terms like fair lending or mortgages and find out about rulemaking across the entire federal government. The filters can also help you home in on what you most need to pay attention to. Once you've identified a rulemaking that you particularly care about, you need to make a decision about how to engage strategically. As an advocate, you have the power to say with authority what rules will impact the communities you serve. This is precisely the kind of substantive input that agencies are required to consider in the rulemaking process, and they often struggle to get it. But before you just jump in and write a comment letter, let's pause for a second. What is the agency's relevant congressional mandate? How far along is the rulemaking? What is industry asking for? What public input or research has the agency already gathered? Most of this context will be available in the Unified Agenda. So here's a checklist as you assess your potential strategic contribution. First, review the agency's legal authority and statutory mandate. Next, become familiar with the procedural history of the rule and understand if the agency has already taken public input or undertaken research. The Unified Agenda is not always perfect, and so other resources may aid your research. More often than not, though, the Unified Agenda will have what you need to get started. So if you only have 30 minutes to decide whether it's worth it to write a comment letter, that's the place to go. These questions will help you settle on an appropriate and achievable goal for your regulatory advocacy efforts. The quick guide that Diane shared in the earlier segment has 6 potential goals you can think about. And thinking about the context of the rulemaking from the agency's perspective will help you settle on which of those 6 goals might be best in your situation. Next up, after you've identified a rulemaking and a goal, select a tool. Maybe in your research some complexity has surfaced. Maybe you've noticed that an agency seems to want to finalize a rule, but they're likely to be sued by industry. Maybe your research has revealed that the agency has been taking too long with a congressional mandate and progress is not being made fast enough. You can match your tool selection to the problem given the context you've learned about. Your message will be the same. You know what you know. You know how this rulemaking will impact the communities you serve, but how best to tell that story? Would it be effective, for instance, to go to the media, or would it be better to ask for a private meeting with the agency? For some of you as well, you may be fielding concerns about LSC rules. Legal Services Corporation funded organizations can legally engage in many forms of regulatory advocacy. In the written materials for this session, we provided a 1-page guide on what you can do with LSC funds, what you can do with non-LSC funds, and what is prohibited if you are an organization that has any LSC funds. To recap that briefly, you're permitted to communicate with government agencies to seek information or clarification about their work, even with your LSC funds. You're permitted to advocate for changes in agency practice that respond to the needs of your client communities. Using funds that are not your LSC funds, you may also write comments in response to rulemaking. When the agency solicits your point of view, you can also share that. However, there are prohibitions to consider. You should not engage in conversations with agencies absent an invitation from the agency to state your point of view or tell a government agency what they should do, again, absent that solicitation in a rulemaking process. So all of that in a nutshell is how you get started with regulatory advocacy in terms of nuts and bolts. At CREA Project, we have lots of resources available to walk you through this at www.creaproject.org/advocates. The first principle of administrative law that I want to talk to you about is inclusiveness. One major difference between legislative advocacy and regulatory advocacy is that in the context of agency rulemaking, administrative law requires the agency to level the playing field for all participants. The level playing field in rulemaking enables individuals and organizations without special access or power to be influential. It means that an argument on the merits will often determine the outcome of the rulemaking rather than the status of the person who made the argument. Administrative law at its core is concerned with the quality of policy decisions and how they're made, rather than any particular document. The Administrative Procedure Act, a foundational statute in administrative law, emphasizes this focus on the decision-making process by defining the term rule very broadly. So, when an agency is making an important policy decision, there are at least two things that agencies must always do. First, agencies must make policy decisions on the merits. Courts can prevent implementation of agency decisions that are arbitrary, capricious, or an abuse of discretion, or otherwise not in accordance with the law. Agencies must examine the relevant data and articulate a satisfactory explanation for the action, including a rational connection between the facts found and the choice made. Regulatory advocates can leverage this by making their advocacy factual, ideally by offering qualitative or quantitative data. As an advocate, you can stick to your expertise as you do this, such as by stating how prevalent a concern is among your clients and how the agency actions would affect them. Second, agencies must respond to significant public comments. Specifically, an agency must consider the relevant matter presented in a public comment, and it must state in its notice of final rule a concise general statement of the agency's response. An agency is not required to include in the final rule a response to every single comment it received, but it's obligated to respond to significant comments, where if the agency had done what the commenter suggested, it would have changed the agency's proposed rule. Regulatory advocates can leverage this by making their comments unique and substantive. Comment letters that merely express an opinion or that echo statements of support that have been made by others will not prompt a rule writer to engage deeply with that comment letter. On the other hand, a comment letter that's unique will get a lot of attention. This is our checklist for using the administrative law principle of inclusiveness in your regulatory advocacy. First, get advance notice of upcoming agency decisions, such as by reviewing the unified agenda. Next, participate in agency decisions by providing facts, ideally qualitative or quantitative data. Next, make your comments to agencies unique and substantive, and in doing so, focus on what expertise you have and what you know about the communities you serve. The second principle of administrative law relevant to regulatory advocacy is transparency. However, just because an agency makes information available, that doesn't necessarily mean that a regulatory advocate will be able to find it or understand it. Our view at CREA Project is that agencies do produce all the information necessary to ensure there is accountability for how agency decisions are made. But regulatory advocates have not yet organized themselves around the tools that are at their disposal. At CREA Project, we recommend these small, ongoing commitments to stay organized and on top of agency actions about policy matters that are critical to communities you represent. First, learn about the agency that you're engaging with. Look up the agency's organizational chart and discern which portions of the agency develop policy that matters most to you. Make a list of routine reports that an agency will publish and get familiar with their publication schedule so that you can follow up. The next step is to do that follow-up. Follow up on routine developments, pay attention to the dates of congressional oversight hearings, and if you can't watch the whole hearing, just read some press clips afterwards to keep track of what happened. Track and advocate for planned agency actions that you care a lot about. If an agency has said that they'll address a policy concern, their planned follow-up should be in their regulatory plans, their strategic plans, their budget documents. So look for that thread continuing through all of that information that an agency puts out. The last principle of administrative law that I'd like to talk to you about today is due process. For instance, due process rights require that government agencies provide fair notice to regulated entities before they impose civil monetary penalties on a regulated entity for violating the law. A regulatory advocate can leverage this principle of due process by realizing that it legitimately constrains how agencies can regulate industry. Advocates can be a partner for agencies in managing this constraint. Here are a few typical situations where agencies might be constrained by the principle of due process. First, in the context of new rules, there's always a risk that industry will sue the agency to prevent implementation of vague rules. Agencies may feel compelled to issue guidance documents quickly after the rule is finalized, perhaps without adequate public input, to make it more likely that the rule as a whole will be implemented successfully. In the context of changing conditions, such as disruptions due to technology, industry may seek clarity about what conduct a rule prohibits. Agencies may feel compelled to offer guidance to support positive change. If an industry broadly opposes regulation, an agency may be daunted by the resources involved in enforcement. So the agency may enforce a rule in a way that's narrower than what Congress mandated when it passed a law or what the agency envisioned when it originally wrote a rule. Regulatory advocates can do several things when they communicate with agencies that will help agencies navigate these situations. For example, let's say that an agency drafts a proposed rule with a, quote, bright line standard for what business conduct is prohibited and what is allowed. A regulatory advocate may correctly point out that some harmful activity will still occur under the bright line standard. However, it would be more effective for a regulatory advocate to go a step further. An advocate could provide specific feedback on how the standard would likely impact their clients and give it some more detail. Ideally, an advocate may even suggest an alternative proposal that would still have that bright line, but under which their clients would be better served. A second way a regulatory advocate can be effective is to maintain public attention on rules in their implementation phase. Agencies are aware of industry pressure in this phase, but industry is less likely to be brazen in its demands for guidance between when the rule is finalized and when it goes into effect if industry knows that there are other actors and stakeholders out there watching what's happening so that the agency can stick to the original intention of the rule at this critical time. And that, in a nutshell, is everything that you really need to know about administrative law. Don't let it trip you up. You already have all the expertise you need to be an effective regulatory advocate.
Hi, so I'm back again to talk about how to write an effective comment. I know we've been encouraging you to think more broadly about regulatory advocacy than just writing a comment. Comments, though, for all of us remain one of the critical things that we do when we're engaged in regulatory advocacy. And the things that we're going to be talking about in terms of how to write an effective comment are also techniques that you're going to want to use whenever you're engaged in any kind of regulatory advocacy. As we said at the beginning, there are 3 basic strategies that you want to use whatever the kind of regulatory advocacy is that you're engaged in. The first is always to use facts. What are the facts? What do the facts tell us? The second is to tie the advocacy into the agency's statutory mandate, whether it's a specific mandate, as in the case of the CFPB under the Dodd-Frank Act, or whether it's a specific statutory mandate, like the Truth in Lending Act, for example. And then the third thing is to be willing to ask questions, whether that means calling up the staff lead on a rulemaking to ask questions or asking for a meeting with the director to ask questions about what the director is looking to do. Just to be open to hearing what the agency's perspective is and what you can learn. When you write an effective comment, you want to always be thinking about what you know. You have a unique perspective. Kate was talking about this in the context of administrative law and how you don't need to be an admin law expert to write an effective comment. You just have to know what it is you know. We believe that writing comments really can be as easy as sitting down and telling a friend a story. What did you see in your practice today? What's happening with your clients? How are your clients impacted by coronavirus? What's happening with their ability to access credit? What kind of credit do they need? What's happening with debt collection? Those stories, when you collect them, when you tell them, they become data. They don't have to be confined to the realm of anecdote. Those stories put together, compiled, analyzed, that is factual evidence that the agency must consider. We talk a lot more about exactly how to talk about what you know that the regulator doesn't in writing an effective comment to proposed rule, commenting effectively. That is also in your materials. And when we finalize the next version will be up on our website. You want to make your policy points in a way that presents trade-offs. You want to think about what are the alternatives that they should have thought about? What are other alternatives that they could do? Would doing nothing be better than what they're doing? And when you do that, you want to think about how can you use the language of cost-benefit analysis. We have a whole document on the CREA project website that talks about how to work with cost-benefit analysis as an advocate. Cost-benefit analysis we think is scary. We don't like it because it feels like it's boiling down to monetary values, these non-monetary values that are so important, these dignitary harms, this qualitative impact that access to credit can have on people's lives. Access to good credit can enable people to have lives that are fulfilling and that let them achieve their goals, that let them build a more secure future for them and their families. Access to bad credit can destroy lives. All of that is appropriately the subject for cost-benefit analysis. Cost-benefit analysis includes both quantitative harms and qualitative harms, and quantitative benefits and qualitative benefits. And additionally, just because something is quantitative doesn't mean it's monetizable. So you should be thinking about, when you think about cost benefit, how can you quantify the harms even if they are ones that you cannot assign a monetary cost or benefit to them? So how many clients do you see that have this problem? How common is this problem? What is the nature of the harm on your client? You want to talk about all those kinds of things. How does cost benefit analysis impact them? We also have nuts and bolts on how to submit your comment. That's in the how to comment. It's a one-pager checklist just for you go through, chop, bum, 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 bum. Tells you how to set up the comment, how to check, where to get the information, what the form should be, has a couple of little tips about how to do it more effectively, but it's really just meant as a quick, easy checklist. One of the things that you should always do is you should remember your audience. So we've mentioned this a couple times before, but rule writers are not the same as judges and juries or legislators. They have different tasks that influence the kind of information that they're looking for and how they're primed to hear it. Rule writers write rules. They're trying to write rules that are enforceable and receive deference from the courts. They're bound by the Administrative Procedures Act. They have to write rules that meet those requirements, rules that are based on evidence, that are based on reasoned analysis, that are within the scope of their delegation from Congress. They care about stories. Stories can influence them. Stories can make concrete a harm, but far more than what's happening in the story, the emotional impact of the story, they're going to want to know what the facts are, how big a problem this is. They're trying to solve for the whole societal problem, not just an individual client. And unlike a legislator, they're not bound directly by what the public thinks. They aren't necessarily responsive to public sentiment. Their boss may be. If their boss is under a lot of political influence and is heavily susceptible to political influence, their boss may care a lot about how public sentiment sways. But unlike a legislator, the rule writers themselves are not going to be impressed if you show up with a whole bunch of constituents. But they may be impressed if you can explain to them why these stories of these constituents represent a common problem, demonstrate a common and pervasive harm. Judges and juries are making decisions on specific cases on the facts in front of them. In theory, they're not interested in public sentiment at all. And the emotional story is very persuasive so long as it's connected to a legal theory. When you are telling a story to a judge or a jury and you are telling how this person was harmed, part of their job is to make that person whole. The job for a regulator is not to make any individual person whole. Their job is to try to balance the trade-offs across the society to make sure that the outcome for the society is better on the whole rather than a case-by-case scenario. The main point I want you to remember when you're talking to an agency is you want to think like a litigator. Think about the persuasive value of what you're saying. Think about the emotional and rhetorical weight of your saying, but talk like an expert. And by that we mean be analytical, present facts in a way that is reasoned, calm, dispassionate. One of the most important things that you can do when you're trying to write an effective comment is in your initial decision about what you're going to comment on. When you approach a rule or proposed rule or an advance notice of proposed rulemaking, you don't need to comment on everything. You don't need to cover the field in what you comment. Unlike a brief or unlike lobbying on a bill, you don't have to address every aspect. You only have to address the places where you have something you want to say, something specific. So when you're looking at a notice of proposed rulemaking, look at it and always be thinking about this question. What is it you know? And what is it the agency rule writers do not know or are not considering adequately? And it's in that Venn diagram, in the intersection of what you know and what the agency rule writers do not know, that you want to put your comment. That's the sweet spot for your comment. That's where you can maximize your contribution and your influence on the rule writers when you're presenting them new information or information they have not adequately considered. So that's the place always to start and always to focus on. Now we're going to go to another polling question. And then after the polling question, we'll have about 5 minutes to take questions live. And remember that we'll be able to answer additional questions during the live Q&A on November 13th from 3 to 4, and as well as the strategy session on regulatory advocacy on November 17th, 3 to 4:30. Thanks very much.